Hey, it's Chad Brown. Welcome to another episode of the Disability Expert Podcast, where we talk about all things Social Security disability. Back with my trusted associate, Aaron Dalton.
Good to be back.
So we want to go through today and walk through and help you understand what is a CDR, what's the process sort of look like, give you a few tips to take away that you can say, this is what you should be doing after you win your case before this CDR potentially happens, even though it may never even happen. And these are things you should do when you actually get that letter in the mail. All right. So I'm done talking. It is your turn. Tag, you're it. Tell our folks what is a CDR. Just sort of walk through the basics of it.
We'll start with the timing. In theory, everyone is supposed to be reviewed 5 to 7 years to determine if those conditions have improved. What we see in practice, though, is that certain groups tend to get CDR'd more frequently. Young people tend to get reviewed more often than every 5 to 7 years. Folks who are 55 and older very rarely undergo a continuing disability review, absent some unusual circumstances we may get to later if we have time. The question with CDRs is, has there been medical improvement since the most recent comparison point decision? So if the most recent decision on your case was at the administrative law judge level, that's what they'll use. If there's been a CDR in the past that found your disability continued, that's what they'll go off of. And what they're looking for is, has there been medical improvement related to the ability to work? So sometimes we see decisions where there's maybe been a little bit of medical improvement, but it was so slight they don't even really proceed further. They say that's not even related to the ability to work. You're almost as bad off as you were last time. We're going to leave you alone. They sort of start their review process. It's not quite the 5-step sequential evaluation process, but it's somewhat similar. They sort of start off looking at the conditions that you had at the comparison point decision. And if those conditions remain disabling, that's all they look at. But if they're looking at your file and they say, well, there's been some improvement in those same conditions from last time, we don't think those ones by themselves remain disabling, then the next question is, well, what's new? And so they'll look at any new conditions that have arisen since the last time they reviewed your file.
So they'll look at it and basically say, I mean, there's a bunch of different possible outcomes. They could look at it initially and say, you haven't gotten any better, or frequently you've gotten worse.
Gotten worse,
right?
yeah.
And, so that, you'll be approved. You'll be your benefits will be continued. They can look at it and say, well, we think your medical conditions have improved, but not necessarily improved to the point. I mean, you rarely see this, but this is what they're doing. Not the point you could return to substantial gainful activity. Your benefits will be continued.
Right.
They could review it and say, well, we think your condition has improved such that you could return to substantial gainful activity, but there's new conditions, and they look at those, and those new conditions in and of themselves could be disabling,
Right.
or in conjunction with whatever level of disability you residually have from the impairments that led you to be disabled to start with.
Yes.
Right. Or they could look at all of that and say, hey, you're not disabled. Yeah, your new conditions aren't enough either. Right. So I think one thing to remember, and this is sort of at the points at the end, but sometimes we run out of time, and I want to make sure people understand this. When you get that letter in the mail, you cannot ignore it.
Right.
So what, for example, would you tell someone when they receive this letter in the mail? This is what's coming, this review process we just described. Primarily, what are the advice you're going to give someone? Because our clients call, our former clients, and we have thousands of them, our former clients call in when this happens. And we do, and there are attorneys who help people with CDR cases. Our firm does CDR cases, for our former clients and for other clients. What generally are you making sure, hey, make sure you don't do this, and these are the things we need to do?
The first thing, if they're one of our former clients and we, maybe they're younger, we sort of expected that there might be a CDR in the near future. What I try to remind clients when we get that favorable decision way back when is go ahead and start keeping a notebook now. And anytime you see a new medical provider go to the hospital, anything like that, put that in your notebook. So when we have that CDR, you have a quick reference point.
So one of the things, to stop right there, one of the things people need to understand is preparing for a CDR starts the day you get your favorable decision initially.
Yes.
Yeah, and that seems that's not the most that's not the favorite advice we give people because they just got up through the process. They're like, oh, by the way, you could have to do this again.
We're not optimistic people.
Yeah, but at the same time, that is really when it starts.
Yes.
Yeah. Okay. So let's say you've done that and you've kept your evidence and you've gone to the doctor and you've complied and all the things you're supposed to do, and you actually get the letter. What are some tips you're going to give people at that point?
Yes. Get that letter back as quick as you can. What it's going to be asking for is essentially updated treatment since the time of the favorable decision or the last time they reviewed your file. And sometimes, like we said, that could be 5 to 7 years of doctor's visits that you're trying to go back and remember who all you've seen. But it's very important to be thorough there because this is the basis for the continuing disability review is the medical improvement. So take your time filling that out, make sure it's very thorough, but also hurry up and get it back in the mail.
And I think too is say, don't please don't do this. Don't assume that it's just about the conditions that got you on disability to start with.
Right.
Because a lot of times what people will come to us and they've been denied, they did their own CDR initial review and they've been denied, or even they did a hearing, the initial hearing, and got denied. And we start talking to them and realize they only updated the medical evidence related to their cancer. But like 2 years after they had disability, they had, bilateral knee replacements. And they're like, well, I didn't think that was relevant because that wasn't what my initial case was cited on. So understand, not only do you need to update that record initially, I mean, you just, fire the shotgun. Anything that's going on with you, you need to go ahead and get all that evidence in. Okay. So I think two big takeaways are be prepared to give the full medical history since the favorable decision, and don't ignore the paperwork.
Yes.
So let's say you send the paperwork back in and they do deny you. Can you walk people through that first sort of the reconsideration phase and the hearing phase so we can sort of give them an idea of what to expect?
Absolutely. So you've gotten that paperwork in, you filled it out, you sent it back, and you get that initial denial. Then you have 60 days to appeal, but this is important, only 10 days to request benefits be continued. So I always try to make sure that clients know you can actually have your disability benefits and your Medicare continued throughout the continuing disability review process.
With the caveat.
With the caveat that you only have 10 days to request benefit continuation from the denial.
And an understanding that you can continue those benefits, but at the end of the day, if they determine your medical condition is improved and your benefits are not continued, it's going to produce an overpayment.
Yes, you may be on the hook for repaying that.
And that probably is not going to be 2 or 3 months of overpayment.
Right, because we'll talk about the process here.
Yeah.
It could be years.
Yeah, so it's not uncommon, especially in past years. There's no reason to think it's going to be different in the future. I mean, it's not uncommon. You could easily produce an 18 to 24 months of overpayment. So run some real quick math. If you're drawing $2,000 a month and you produce 24-month overpayment, that's $48,000 that you're going to be responsible for. Not saying don't continue your benefits, just understand there is risk there.
Yes.
There's waiver process as well. That's probably another whole episode we're not getting into today, but understand you have 10 days to continue your benefits and understand there's risk there.
Right.
Okay. So you get your notice, you continue your benefits, you go to reconsideration. What's that? There's a hearing there.
Yes, this is a little bit different than the reconsideration on an initial kind of standard run-of-the-mill case. At CDR level, a reconsideration, you can actually request a hearing with a local officer at your local Social Security office. So we typically do recommend people take advantage of that, have that local officer hearing, and essentially it's usually about an hour, relatively informal interview with a local officer who is not an attorney, who is not a judge or an ALJ. This is somebody who works with Social Security and sort of has a form that they fill out of questions that they're asking you.
You know, they're very diligent about completing the form.
Yes. Some of the questions you'll be sitting there thinking, this has nothing to do with my case. Why are they asking me that? It's because it's on the form and they must have an answer.
Yeah, they must complete the form.
So the form will be completed, and then they will issue a decision. If they decide that there's been medical improvement, then the next step is to appeal that and go in front of an administrative law judge, very similar to the hearing that got you on benefits originally.
Yeah, and I think a couple of things. One, I mean, we represent people in CDRs, and we will do a local hearing with them.
Yes.
I think it's important to do that hearing. One is it gives you an opportunity for your client to have sort of a dry run at testimony, which is sort of like a deposition almost in some respects. You have and you're able to also. Well, I've never felt like the hearing officer really cared what we had to say. Maybe they do. That's probably not complete. It doesn't feel like they care.
Their
Like,
forms are just so thorough. There's nothing left for us to
what
ask.
could there possibly left for us to ask that wasn't on this wonderfully created government form? But it also gives you an opportunity as an attorney because it's a dry run. It's not binding.
Right.
I mean, just because the hearing officer says you had medical improvement, it's kind of like anyone at DDS saying you have medical improvement. It really doesn't matter.
The judge can consider it, but they're not required to follow it.
Yeah, and in my experience, judges particularly don't feel like they have to be bound by a hearing decision and CDR. But it gives you an opportunity also, though, to do an evaluation of the case.
Yes.
You know, what are some things we need to deal with? What are some issues? Do we need to go back and get an additional letter of support to maybe explain why the records that the hearing officer is looking at is sort of leaning towards medical improvement, but maybe that's really not indicative of medical improvement? I think it's an opportunity for you to not only evaluate the case, you get a chance to go through the testimony, and you get a very, very thorough decision.
Yes.
It looks nothing like a reconsideration decision in a sort of initial application. And they're going to go through and look at the comparison point decision. But it's going to be very similar to what an ALJ is going to do. So if you see that maybe sometimes they mischaracterize the initial impairments that were part of the underlying decision. I mean, it's not uncommon for them to, like you read it and you're like, I did that hearing and I know it's 4 years ago, but I don't think that's what was wrong with them. And you'll go back in and sure enough, they've completely sort of just mischaracterized what was going on, or they're like, well, they really hyper focus on one issue. And you're like, well, that wasn't important when we did the hearing to start with. Like, that's not why they were found disabled. And sort of sometimes there seems to be a disconnect between their review of the comparison point decision and what actually happened in the comparison point decision. So it's just a good way to get clarity on those things and sort of how they work. So to say they deny you again, you're going to go to an ALJ. What generally would they expect in an ALJ hearing?
Very similar format-wise to a standard run-of-the-mill hearing, the hearing where you got your benefits. The judge is probably going to be asking some questions about sort of what have you been up to in the last couple of years. Depending on the judge's interest, they may be laser focused on the impairment that got you disability in the first place. Other judges will want to talk more about things that are new or different.
Interesting. I think in the ALJ hearings in these cases, there seems to be a sort of a broader look at your ADLs. There's a broader look at your life. There's a broader look at how you've been spending your time, whether you've tried to work, whether maybe you've taken up one of those gig economy jobs that we talked about a number of episodes ago. And so I think it doesn't appear to, in my experience at the local office hearing in the CDR, like, it's just not a big part of the form, right? But at the hearing level, your judge is going to dive into those.
I think the ALJs are also more comfortable than the hearings officers sort of questioning your treatment. So an ALJ is maybe very comfortable coming in and saying, now that you've had Medicare for 4 years, why haven't your doctors done this, that, and the other? Right. And so sort of being prepared to explain yourself as far as what treatments you've been having.
Even though the regulations clearly say that the ALJ cannot be a doctor, they sure seem to Monday morning quarterback what yours have been doing in these CDR hearings. So I think generally too, just understand what happens from the hearing into the CDR notice matters. And so if you aren't over 55, say when you get approved, you probably should anticipate, by statute, you should have a CDR. Evidentiary wise, I think it's sort of the same things we always talk about. You need to have consistent treatment. You need to follow the treatment recommendations of your doctor. If you don't, you need to give good explanations. You need to continually be aware that if you're in a hearing, there's going to be this golden chain of evidentiary progression. We have to have the diagnosis. So if you need to maintain medical treatment to maintain the diagnosis, you have to be able to show the symptoms through your testimony and through the medical treatment. Then you have to be able to clearly describe functional limitation. So it's both detail, and really framing it in sort of ways that are believable. So I can't lift this much, and I know that because I can't sit for this long, and I can't sit that long because. And so at some levels, it's no different than your original hearing, but at another level, understand you're now going to be judged not on what happened before your original hearing. You're going to be judged on what happened after it and what the records show and what they do. So
I think that's one thing sometimes clients get a little bit mixed up on is at the CDR, generally, nobody's questioning that you were disabled back then. And so they're not going to undo that decision. They're just looking forward from there.
Yeah. I mean, even though, Judge Tenazamal sometimes seems to question that, but even sort of, low approval judges are really not going to take away your benefits unless there's documented improvement of the condition. One final thing, because my lovely producer is calling us home. Yeah, time flies when you're having fun. This is also, though, one of the times where fraud investigations happen.
Yes.
So obviously, CDRs do not happen necessarily because of fraud. That's not the requirement, but they can happen because of fraud. Or sometimes in the course of the CDR, they determine they think you're committing fraud. Can you talk just briefly about how those investigations work, just what someone could expect, and when, goodness gracious, they need to shut the door and call a lawyer?
Yes. So the CDI Cooperative Disability Investigation Unit, or what I call the fraud squad, may show up at your door, and it'll be officers in, it looks like FBI jackets, but it doesn't say FBI, and they will start asking questions. You need to hire a lawyer right then. They may not just talk to you. They might talk to your neighbor, guy at the corner store, and then there will be a report added to your file. It's usually, I've seen ones that are 30 plus pages long about all of these different interviews that they've conducted and why they think you're committing fraud. The judge is not bound by that report, but it's certainly something the judge can and will consider in your case.
Yeah, I think the reason we see it here is that frequently these investigations turn up in CDR cases,
Right.
Because it's not fraud to continue receiving benefits after you've medically improved,
Right.
per se. But it is fraud if you know that you've had medical improvement and you're working a side hustle for cash
that you never told Social
that
Security
you never
about.
told Social Security about, or you're doing you're conducting yourself in a way that gives ready evidence that you know that you're fraudulently receiving these benefits. And once again, they can be, those investigations can produce hundreds of thousands of dollars
Right.
In penalties, and it's crime.
Yes.
So not only now do you lose your benefits, now you're in a criminal case, which is why you need to call a lawyer.
Yes.
All right, man. CDRs are coming. If you tell me in 2027 there's not more CDRs, then I'll buy you a steak dinner or
I'll be
something.
shocked.
Yeah, I'll be shocked because they didn't change the way these are being done to do less of them. And so be prepared. If you're on disability and you're receiving benefits, just do the things you need to do. Go to your doctor, maintain your medications. If you go back to work in some capacity, and let Social Security know. But what you want to do is be able to come into a CDR saying, "Hey, I've done everything I was supposed to do to maintain my health, and I disclosed to you anything that you required me to disclose to you." And then, you're at least reasonably likely going to be protected for fraud, right? All right, so very good. All right, that's all the time we have today. CDRs, if you get that notice in the mail, I'm sorry, it's no fun to get punched in the face. Fortunately, my lip's not completely busted. But anyway, it's no fun, but hey, you don't have to do it alone. Hire someone, get a good lawyer to help you work through those. And until next time, take care. Oh, subscribe. Thanks.